Thank you, Mr. President. Mr. President, last night I announced that the Senate Judiciary Committee, which I chair, will vote to subpoena Harlan Crow, Robin Arkley, and Leonard Leo, two billionaire megadonors and one of their enablers, who sit at the center of the ethical crisis currently gripping the United States Supreme Court. This vote is the next step in the committee's ongoing investigation on the ethics of the Supreme Court. It comes only after Mr. Crow refused to comply with committee request and Mr. Leo and Arkley outright stonewalled the committee in the exercise of our constitutional authority. For years, Mr. President, reports of ethical misconduct by individual justices on the court have raised serious concerns. But over the past year, a series of investigative reports have brought the long-simmering issue to a boil. Story after story has emerged about lavish gifts and luxury trips that Supreme Court justices shamelessly accepted and failed to disclose. The reported behavior is unworthy of anyone in public office, and it has led to an historic loss of public confidence in the Supreme Court. Some background here is necessary. Harlan Crow is a billionaire and a Republican megadonor. He first met Justice Clarence Thomas in the mid-1990s after Thomas' confirmation to the Supreme Court. Not long after they met, Crow began to shower Justice Thomas with lavish gifts, flights on his private jet, invitations to an all-male invitation-only private club, a $19,000 Bible that once belonged to Frederick Douglass. We know about these initial gifts because Justice Thomas listed them and disclosed them on the financial disclosure forms he was required to submit under federal law. But those disclosures abruptly stopped in 2004, almost 20 years ago, after a Los Angeles Times report questioned their propriety. We've since learned that Justice Thomas continued to accept gifts from Crow that are staggering in both their number and value, from additional flights on Crow's private jets to nearly annual stays at Crow's luxury camps and private clubs, to vacations on Crow's super yacht. Justice Thomas simply stopped disclosing these gifts to the American people. But Harlan Crow is not the only billionaire bankrolling the lavish lifestyle of a Supreme Court justice. And Justice Clarence Thomas is not the only justice to accept improper gifts. Let's turn to Robin Arkley. In 2008, Arkley hosted Justice Samuel Alito at his luxury fishing lodge in Alaska. There, Alito fished, flew on the lodge's bush planes, and enjoyed wine costing upwards of $1,000 a bottle. $1,000 a bottle. Justice Alito included none of this on his financial disclosure, nothing. That 2008 luxury fishing trip was arranged by a man named Leonard Leo. Leo has been a longtime leader of the Conservative Federalist Society and other far-right organizations. He is the key architect of the right-wing campaign to take over the federal courts, facilitating relationships between political donors and justices, championing conservative political causes, and wielding a shadowy network of influence over federal and state judges. How can a Supreme Court justice accept such lavish gifts, let alone fail to disclose them to the American people? The answer is very simple. The Supreme Court of the United States, the highest court in the land, does not have an enforceable code of conduct. Unlike employees of the executive and legislative branches, virtually all of them, unlike members of Congress and all other federal judges, the 9 Supreme Court justices alone decide for themselves what conduct is and is not appropriate. More than 11 years ago, I asked Chief Justice Roberts to adopt a binding code of conduct for all Supreme Court justices. I've renewed that request repeatedly this year, including last month when I sat literally physically next to the Chief Justice and spoke at the Judicial Conference. Some justices have now publicly joined the call for an ethics code. I do believe the majority of the justices on the Supreme Court are embarrassed by these disclosures and want this to come to an end. So far, the Chief Justice, John Roberts, and the court have failed to do anything. In the face of the Supreme Court's failure, the Senate Judiciary Committee has exercised its constitutional right and duty to investigate this ethical crisis in order to craft and advance legislation to address it. Beginning in May, the committee has sent letters to a number of these billionaires, activists, and organizations connected to the undisclosed gifts and travel. I'm sorry to say I happen to believe that we have just seen a small amount of the lavish gifts that have gone to the members of the court, thanks to the investigative efforts of journalists, as well as the Senate Finance Committee. We've discovered some of these things, but sadly, I believe there's much more out there. We are seeking details about what exactly has been given to these Supreme Court justices, as well as how certain individuals and groups that have business before the court gained such enormous access to the private lives of these justices. Getting this information is critical. While there's been reporting on the justices' ethical failures, I'm sorry to say that there's more information out there we need to find. Just last week, listen to this, the Senate Finance Committee revealed that yet another wealthy benefactor, Anthony Welters, had forgiven a $267,000 interest-only loan to Justice Thomas to purchase a luxury RV. Justice Thomas failed to disclose that. So you understand what happened. The justice who seems to fancy these RVs had his eye on one that cost over $250,000. Mr. Welters agreed to loan him the money to buy the RV. Justice Thomas made one annual payment of interest on that debt, and then the debt was forgiven. And so the RV is his, a gift from Mr. Welters. While the loan itself had been the subject of prior reporting, it was only through the Finance Committee's investigation and the cooperation of Mr. Welters, let me add, that the favorable terms of the loan and its ultimate forgiveness came to light. In contrast to Mr. Welters' willing cooperation, Leonard Leo, Harlan Crow, and Robin Arkley, more of these fawning billionaires, have produced no substantive response and have otherwise stalled the Judiciary Committee's investigation. Instead, their responses offer a host of baseless arguments that ignores the committee's constitutional authority to inform its legislative efforts. Their defensive and dismissive response make you wonder, what are they trying to hide? I'm not going to stand idly by as these fawning billionaires with interest before the court use their immense wealth to buy private access to the justices and then deny the Senate Judiciary Committee information to which we are lawfully entitled. That is why the committee will vote to authorize subpoenas to these individuals. Mr. President, this has been a long battle for many of us, and my colleague, Senator Whitehouse, has shown extraordinary leadership on this issue as well. 11 years ago, it came to my attention that the Supreme Court just didn't have a code of conduct. How can we justify this? 9 justices on the highest court in the land, no code of conduct. What about the other federal justices? They're bound by a code of conduct. If the justices on the Supreme Court merely assume the same type of conduct with some modifications, we would at least say they're making a step in the right direction. But they ignored it and they resisted it. In fact, Justice Alito and Justice Thomas have been belligerent when they've been confronted with these issues, that it's no one's business but their own as to what they do with their private lives. Unfortunately, when you accept the post in public service, that is not the case. Our private lives become part of that public service. And certainly if there is any suggestion of a conflict in a situation where individuals, billionaires who have an interest before the court are buying access and time with these justices, that is certainly relevant to our work in the Senate Judiciary Committee. Mr. President, as a member of the committee, you understand we have gone through this process very deliberately and patiently and slowly and reached a point where we believe subpoenaing this information is the only way to get the facts before the American people. I'm hoping that this is successful. I hope that it becomes bipartisan, and I hope that we bring this to this court the type of reputation which is enjoyed over the years. I yield the floor. To speak on a separate topic and that it be placed in a separate part of the record.
Without objection.
Mr. President, you were there yesterday. the Senate Judiciary Committee met. I chair that committee, and we had a strong turnout of Democrats and Republicans to consider an issue which everyone's read about or heard about over the last several weeks, and that is the ethical standards applied at the highest court in the land, the United States Supreme Court across the street. We've all read the news stories that led to this hearing. Questions raised about one particular justice, but not him alone, in terms of gifts that they've received and whether it influences their decision-making on the court. That is basic and fundamental. If you think the fix is in on a court, you don't have much respect for their operation. So the question is, what's going on in the Supreme Court? And as it turns out, as you well know, we have ethical standards all across the federal government that apply to the members of the Senate and the House, the executive branch, and to all of the courts below the Supreme Court in terms of financial disclosure and basic rules of the road of what you can do and what you can't do. For example, there's a basic standard that is used for gifts for members of the Senate and House that puts a limit of $50 on the value of any gift. I have returned gifts given to me which I thought exceeded that value. I'm sure the presiding officer has as well. But that's our standard. There's no such standard, as best we can understand, when it comes to the Supreme Court, the highest court in the land. So it turns out the highest court in the land has some of the lowest ethical standards. Why? Well, when this came to light in the news articles about Justice Thomas, I wrote to the Chief Justice of the Supreme Court, John Roberts, and invited him to come to the hearing yesterday to tell this side of the story. What is the Supreme Court doing when it comes to ethical standards? They don't play by the same rules as all the other courts in America. What are their standards? Well, the Chief Justice declined my invitation and sent along some documents to indicate what he thinks are the rules of the road for ethics in the Supreme Court now. They were interesting, but unfortunately, they revealed that the standards at the highest court in the land are not even equal to the standards at all the other federal courts. So we had a hearing yesterday on the subject, and we invited witnesses from the Republican side and the Democratic side to comment on the current state of affairs. If the Chief Justice couldn't appear or would not appear, we went forward with the investigation, which is our responsibility under the law. Now, asking a justice of the Supreme Court to come and testify before a congressional committee is not unusual. 92 appearances have been made by justices on the Supreme Court since 1960 before the committees of Congress. But yesterday, the Chief Justice, nor any other member of the justice on the Supreme Court, appeared before us. So what we found was a surprise to me. I thought there would be some bipartisanship to this, because in the not too distant past, 2 senators on the committee had crafted an ethics bill on the disclosure of stock holdings, sent it not only to the president to sign, but it was embraced as well by the Supreme Court. A bipartisan, thoughtful measure for sure. But yesterday, I'm afraid things were very partisan. First, there was a question as to whether or not this was an attempt to attack the conservative members of the Supreme Court by raising ethical questions. I tried to make a point several times that the first letter that I sent to a Chief Justice, this Chief Justice, on the issue of Code of Ethics for the Supreme Court, I delivered on February the 13th, 2012, during the Obama administration. So this was not some newfound interest. I've been working on it for years. My colleague, Senator Sheldon Whitehouse, also has dedicated a major part of his Senate career to this issue of ethical standards before the Supreme Court. So the notion that we just invented this because of unhappiness with a recent court decision just doesn't hold up. Many of us have been working on this issue for years before any of these decisions were handed down. There was also an argument that Congress has no authority to establish standards for the Supreme Court. As I mentioned earlier, when we had the stock disclosure law passed last year, it was embraced by the court. The court goes through some form of financial disclosure based on a law passed in 1978. And by and large, there are many ways that the Congress interfaces with the Supreme Court, not the least of which is its budget. So we're in constant communication with the court and its operation. I believe that we clearly have the authority to establish ethical standards in law for the Supreme Court. The Republicans, to a person, disagreed with it. We also had an argument made that somehow we had singled out Clarence Thomas, a Chief Justice on the Supreme Court, and decided that he was going to be persecuted by this type of inquiry. Well, let me say the facts that were disclosed about his gift-taking from a Texas billionaire were extraordinary. I think they were a surprise to most people. Justice Thomas has not denied the fact that he took hundreds of thousands of dollars worth of vacations, yacht trips to Indonesia, private aircraft, from this Texas billionaire. He dismissed it and said that it was personal hospitality. Personal hospitality does not include transportation. And of course, this included a lot of the most luxurious transportation imaginable that the justice received. So to say that this was acceptable conduct, it clearly was to the Republicans yesterday, but I think most Americans want to know a little bit more about the relationship that would lead a justice to take hundreds of thousands of dollars worth of trip, not to mention that the same billionaire bought his mother's home and allowed her to live there afterwards. And so that was worth at least $140,000 to the benefit of the justice's family again. There were questions raised throughout as to why we would pick on one conservative justice. I will tell you the disclosures that have come out since the Thomas article about the gifts he's received from the Texas billionaire have included many members of the court, certainly those who wouldn't be put in the conservative category. Questions have been raised. Questions are raised about members of Congress all the time, and they should be. I know each year when I disclose my taxes and my net worth in detail, somebody's going to call with a question. Explain this item to me, explain that item to me. That is part of the responsibility of public service. It's no fun, but it's part of the job. If you want to be a public figure, I think you owe it to the people to be assuring them at every step of the way that you're being honest about discharging your duties. So we haven't given up. When it comes to the Senate Judiciary Committee and the issue of ethics, we're far from finished. We had good testimony yesterday from witnesses that I think give us a basis for moving forward in this area. At the end of the day, we want to make sure that people, as skeptical as they are of politicians, with they have every right to be, believe that the institutions, whether it's Congress or the Supreme Court or the President's office, are at least credible and trustworthy. Establishing a fundamental ethical standard that assures that fact is absolutely essential, and the Senate Judiciary Committee will continue that pursuit. Mr. President, I yield the floor and suggest the absence of a quorum.
Clerk will call a roll.
Ms. Baldwin.
As a member of the Senate Judiciary Committee, you are aware of the fact that I announced last week in the committee that we would vote to authorize subpoenas to Harlan Crow, Robin Arkley, and Leonard Leo as part of the Judiciary Committee's continuing investigation into the ethical situation at the U.S. Supreme Court. I do not make this decision lightly. Seeking authorization to issue subpoenas is a relatively rare occurrence in the committee. So today I come to the floor for a few minutes to explain why we've taken this significant step. Over the last several months, it's become clear that the Supreme Court is in desperate need of a binding code of ethics as we learn of lavish gifts and luxury travel that certain Supreme Court justices have accepted from a gaggle of fawning billionaires. Let's start with Justice Clarence Thomas. The sheer number and value of gifts accepted by Justice Thomas is staggering, and the shamelessness with which he accepted them is stunning. For decades, Justice Thomas has accepted lavish gifts from Harlan Crow, a conservative billionaire with business before the Supreme Court. These gifts have ranged from a $19,000 Bible, once owned by Frederick Douglass, to a $15,000 bust of Abraham Lincoln. Justice Thomas also accepted private jet trips and free lodging at Bohemian Grove, an exclusive all-male invitation-only retreat in the redwoods of California. And these are only examples of what Justice Thomas disclosed. After the Los Angeles Times reported on these disclosures, Justice Thomas, in 2004, 19 years ago, promptly stopped disclosing gifts as required by law. We learned this year that he continued to accept expensive gifts for the past 19 years. and that these billionaire benefactors have been part of a growing list. There isn't time to detail all of the undisclosed gifts which the press has discovered and luxury travel that Justice Thomas has accepted. But for the sake of a record, I'm going to give a few examples. In 2019, Justice Thomas and his wife flew to Indonesia on Harlan Crow's private jet and boarded Crow's 162-foot super yacht, the Michaela Rose, to island hop with Harlan Crow and his wife. The total cost of that trip alone could have exceeded $500,000 if Justice Thomas had chartered the jet and yacht. Lucky for him, Harlan Crow was happy to cover the cost. Justice Thomas also continued to join Crow on trips to Bohemian Grove in California. He visited Crow's ranch in East Texas, spent summers at Crow's private resort in the Adirondacks. But there's more. Crow paid thousands of dollars to cover tuition for Justice Thomas's grandnephew. He purchased real estate owned by Thomas and his relatives, including Thomas' mother's home, where she continues to live rent-free. And Crow donated $500,000 to a conservative advocacy group founded by Justice Thomas's wife. I could go on and on and on, because the list of gifts Justice Thomas has chosen to accept and failed to disclose goes on and on and on. Justice Thomas is not the only Supreme Court justice who's accepted lavish gifts from billionaires and refused to disclose them. In 2008, Justice Samuel Alito boarded a private jet bound for Alaska to enjoy a luxury fishing trip, a trip that should have cost him over $100,000, but it didn't cost him one penny, because of the man who organized the flight and joined Alito on the luxury fishing trip, Leonard Leo. Mr. Leo arranged Justice Alito's free flight to Alaska and his free lodging once he arrived. Their host at the luxury fishing lodge was a gentleman named Robin Arkley. Over the next few days, Justice Alito and his travel companions enjoyed guided fishing trips, flights on bush planes, meals of Alaskan king crab and Kobe beef, and wine costing upwards of $1,000 a bottle. Justice Alito did not disclose any of this. And when challenged, for example, on the jet ride, why that should be disclosed, he said it didn't view it as a gift because if he didn't go, the seat on the plane would have gone empty. That's an interesting analysis of a gift from a strict constructionist. This kind of scandalous behavior cannot continue. One former federal judge who served for years in the Judicial Committee that reviews the justice's financial disclosures had this to say about the gifts to Justice Thomas, quote, "In my career, I don't remember ever seeing this degree of largesse given to anybody." When referring to the cascade of gifts from Harlan Crow to Justice Thomas, the former chief White House ethics lawyer for Republican President George Bush said, and I quote, "This is way outside the norm. This is way in excess of anything I've ever seen." And renowned conservative jurist Judge J. Michael Ludwig stated in testimony before the Senate Judiciary Committee, quote, "The Supreme Court should want to lead by example that only it can set. It should want to conduct itself in its non-judicial activities in all ways such that they are above and beyond reproach." Unfortunately, the Supreme Court has not lived up to this expectation. That's why our Senate Judiciary Committee is exercising its constitutional authority to investigate. Months ago, I, along with my Democratic colleagues on the committee, sent letters to Crow, Arkley, and Leo, among others, seeking details about what exactly has been provided to Supreme Court justices. Our goal has been to understand how specific individuals and groups with business before this court have used undisclosed gifts to gain private access to justices, access not afforded to others. For months, Crow has refused to fully comply with the committee's request, and Leo has completely stonewalled the committee. Only now, under threat of subpoena, Mr. Arkley has stepped forward, and we are looking forward to continuing our conversation with him this week. The fact that we have to go to this length is unacceptable but necessary. The Senate and the American people deserve to know the full extent of how billionaires with interests before the court use their immense wealth to buy private access to our Supreme Court. That's why on Thursday, the Judiciary Committee will vote to authorize subpoenas for these individuals. The vote is a critical step in the committee's exercise of its constitutional right and duty to conduct oversight of the federal judiciary. It is critical to the committee's effort to restore the court's reputation. The highest court in the land should not have the lowest standards of ethics. This is not a fight I wanted, but now that it's come to this, the Judiciary Committee will not back down. Mr. President, most Americans are shocked to know or to learn that the 9 justices on the Supreme Court are the only major elected officials in the United States of America who are beyond the reach of a code of ethics. How do you explain that? How can you explain that every federal judge in America is bound by a code of ethics except for the 9 Supreme Court justices? What's so special about them? The Constitution makes it clear that we don't have royalty in this country, but they're acting like they belong to some regal fraternity or sorority. That's got to come to an end. And when you look at this situation, members of Congress are held to standards, and I'm not complaining. I knew what I was getting into when I signed up for this job. Held to standards of disclosure and limitation on gifts. I cannot tell you how many times I've said to a person, is this worth more than $50? And if they answer, well, maybe it might be, I say, well, keep it and thanks for thinking of me. You know, that's the kind of thing that just becomes routine part of public service. These lavish gifts, particularly from individuals who have business before the court, are just unacceptable and inexplicable. It is important for us to have a response when people ask, what are you doing to clean up the things at the Supreme Court? The first thing we did, I think, was the responsible, respectable thing to do. We invited the Chief Justice of the Supreme Court to appear before our committee and tell us his thoughts on the subject and what he believes should be done to deal with this bad publicity and these disclosures. He declined the invitation. I don't hold it against him. He explained in my presence a few weeks ago why he did. I understand it. I disagree with it, but I understand it. But 11 years ago was the first time I contacted the Chief Justice and said, this has got to come to an end. Tell us what you're going to do about establishing a code of ethics on the Supreme Court. 11 years ago, and nothing has happened since. I want to salute and commend my colleague, Senator Sheldon Whitehouse of the state of Rhode Island. He's been a leader on this topic in the subcommittee which he chairs in the Judiciary Committee, and we have cooperated in this effort. We will meet this week. This is not the first time Judiciary Committee will be asked to issue subpoenas. It happened before under Republican leadership as well, in a much different type of case. But the fact of the matter is that we have tried carefully and studiously to come up with this information the right way, and have unfortunately not had the kind of results we wanted. A subpoena, we hope, will jar loose the information to explain exactly what happened with the gift giving by several individuals. Mr. President, I ask that the next statement I make be in a separate part of the record.
Without objection.
Madam President, history was made today with the release of a document by the United States Supreme Court. Today, for the first time in the history of the United States, the Supreme Court has issued a code of conduct for Supreme Court justices. Most Americans will be surprised to learn that this was the first time this code of conduct has been issued, but that's a fact. I know this issue better than most because 11 years ago, I wrote to the Chief Justice of the Supreme Court, John Roberts, along with several of my colleagues, and told him this establishment of a code of conduct for the Supreme Court justices was long overdue. After years of refusing to act, a series of scandalous disclosures involving several justices on the court, and the Senate Judiciary Committee passing legislation sponsored by Senator Sheldon Whitehouse on ethical reform, the Supreme Court has finally responded. Today, for the first time in history, the Supreme Court of the United States is at least saying to the American people, we hear you. And understand that the 9 justices on the Supreme Court are members of a democratic form of government, not royalty, and that they should be held accountable as all public servants in the federal government are held accountable. At a glance, this code of conduct for justices of the Supreme Court is similar to the standards that apply to all other lower court federal judges. The court's code of conduct sets forth several important canons of conduct, including canons on upholding the integrity and independence of the judiciary and avoiding impropriety and the appearance of impropriety. All of these are important steps, but they fall short of what we could and should expect when a Supreme Court issues a code of conduct. The court's statement on the code specifically notes, and I quote, "For the most part, these rules and principles are not new," end of quote. That's a problem, because the court's previous practices were plainly inadequate. The court's new code of conduct does not appear to contain any meaningful enforcement mechanism to hold justices accountable for any violations of the code. It also leaves a wide range of decisions up to the discretion of individual justices, including decisions on recusal from sitting on cases. I'm still reviewing the court's new code of conduct. For now, I will note that the court's adoption of this code marks a step in the right direction. It may fall short of the ethical standards which other federal judges are held to, and that's unacceptable. And if it falls short, the American people will ultimately have the last word, and the integrity of the court is at issue. We are going to carefully review this proposed code of conduct to evaluate whether it complies with our goal that the highest court in the land not languish with the lowest standard of ethics in our federal government. But this release today, long overdue, begins a dialogue which could end in restoring the integrity of the court, and that is long overdue. Madam President, I'd like to speak on a separate topic, totally unrelated. After nearly 7 years, 6 years, 8 months, and 21 days of being unjustly jailed, former Philippine Senator Leila de Lima was finally released. This is a picture of her waving from the window as she was released. In a moving interview just after leaving the prison camp, she stood by her defense of democracy, human rights, and truth, and reflected on the importance of not succumbing to hate, a reminder of courage and grace. I welcome her release and urge any and all remaining charges against her be immediately dropped. I look forward to seeing her soon. I hope she can make it to Washington. Several senators have followed this case carefully, closely, including the presiding officer. We've sent letters. We've encouraged her over the years to be strong, and she was. Senator Markey was also involved in this effort, and I want to commend him as well. You often wonder when you hear about these unjust jailings in lands far away from the United States, whether there's anything we can do on the floor of the Senate chamber that can change history. Today, finally, after 6 years, 8 months, and 21 days, history came around for Leila de Lima, the senator from the Philippines. She's an extraordinary woman who showed extraordinary courage. I was glad to plead her case before the American people and to plead it to the President of the United States before he met with the Filipino leadership. This is an important thing to remember, that each and every one of us have the power to speak out for those who are otherwise voiceless. She was one, and it ended with good news today. Madam President, I ask that the remaining portion of my statement be placed in the record.
Without objection.
I yield the floor. Mr. President, over the past 2 years, something profound has taken place on this Senate floor. We have been building one of the most important accomplishments of the Biden-Harris administration, the confirmation of highly qualified, independent, even-handed judges to the federal bench. This week, the Senate will confirm the 150th lifetime judge since President Biden took office. This is an historic slate of judges who I believe will rule with reason and restraint. These judges respect the rule of law, adhere to precedent, and above all, answer only to the U.S. Constitution. Some Senate Republicans, including their leader, have not been shy in criticizing these nominees. According to the minority leader's retelling of history, under the former president, Senate Republicans, quote, spent 4 years confirming staggeringly qualified and incredibly brilliant men and women to the court. I'd like to set the record straight, Mr. President. For each judicial nominee that comes before the Senate, the American Bar Association conducts a nonpartisan peer review and ranks their qualifications. Rankings are based on integrity, professional competence, and judicial temperament. And during the Trump administration, Senate Republicans confirmed eight Trump nominees who were found unqualified to serve on the federal bench by the American Bar Association. Compare that to President Biden's record. During the Biden administration, not one of the 150 judges we've confirmed had an unqualified rating. Not one. So when I hear some Senate Republicans waxing about the glory days of judicial nominees under President Trump, I can't help but wonder what they're talking about. Are they talking about that district court nominee who'd never tried a case and had instead worked as a ghost hunter and ghostwriter and written blog posts defending the Ku Klux Klan? What about another Trump trial court nominee who had never tried a case, never examined a witness, never taken a deposition, never argued a motion? Or the Sixth Circuit nominee who likened abortion to slavery? How about the Ninth Circuit nominee whose colleagues called him, quote, arrogant, lazy, and ideologue and lacking in knowledge of the day-to-day practice of law? In addition, some Senate Republicans have relied on increasingly absurd criticism in an attempt to undermine President Biden's nominees. Some Republicans on the Senate Judiciary Committee criticized one of Biden nominees as soft on crime because she had dedicated her career to exonerating wrongfully imprisoned individuals, mainly using DNA evidence. That's right. Senate Republicans argued that releasing people from prison who did not actually commit the crime is somehow dangerous for society. Just last week, one of my Republican colleagues criticized the nominee who has served as a federal prosecutor for 16 years because he did not ask a judge to impose a sentence that was higher than the maximum sentence allowed by law in one case. Let me be clear, this nominee would have been asking a federal judge to violate the law if he had made such a request. Those types of attacks are simply not credible. President Biden's nominees are qualified, and they have demonstrated impeccable temperament. Something that stands out about these nominees, aside from their exceptional qualifications and loyalty to the rule of law, is the professional and demographic diversity they bring to the bench. When you go into a federal courthouse today and look at the judges who are likely to be trying or deciding a case, you're going to find more diversity than ever before. Under President Biden, in fact, we've made history, confirming more black women to the federal circuit courts than all prior presidents combined. Of course, we also confirmed the first ever black woman to serve on the Supreme Court, Justice Ketanji Brown Jackson. And we've confirmed historic numbers of Asian American judges, Latino judges, LGBTQ judges. It's not just demographic diversity that we've seen under President Biden, it's also professional diversity. In the past 2 years, we've confirmed more circuit judges with experience as public defenders than all prior presidents combined. Mr. President, for the record, I've voted over and over again for former prosecutors, white males. The bench is made up of a lot of people that I've voted for in the past, and I believe that they were ready for the job and competent to handle it. But we believe now that there should be more diversity, and this president's making sure the nominees sent our way meet that standard. We've confirmed state court judges, federal magistrates, and bankruptcy judges, and prosecutors who've made significant and critical contributions to this country's justice system. One of President Biden's nominees served as special prosecutor in the trial of Derek Chauvin for the murder of George Floyd. And we've confirmed jurists with experience protecting the rights of voters, the rights of workers, civil rights, women's rights, and LGBTQ rights. Another notable aspect of this record, and this I'm very happy to report, is that the vast majority, nearly 90% of all these judicial confirmations have been bipartisan. Even on the appellate courts, over 3/4 of President Biden's nominees have received support from both sides of the aisle. This focus on qualified consensus nominees go a long way toward restoring trust and faith in our judiciary. Let me also remind you, in the first 2 years of the Biden administration, we had a 50-50 Senate and a 50-50 Judiciary Committee. We needed bipartisanship for anything to work. The American people deserve federal judges who not only look like America, but understand what it means to be an American. That is an important part of our work that we began under President Biden. It's a work we must finish. We celebrate these 150 judges, and we'll continue elevating jurists who are qualified, principled, and committed above all to protecting our constitutional rights. The American people deserve nothing less. Mr. President, I yield the floor and suggest the evidence of the law.
Clerk will call the roll. Without objection.
Thanks, Mr. President. Pending before the United States Senate is the nomination of Daryl Papillon. The Eastern District Court judge wishes to be for Louisiana. I want to say a word about this nomination because it indicates a positive development in the Senate Judiciary Committee, which the presiding officer and I share membership in the fact that this is a bipartisan nomination. On May 11th, Daryl Papillon was voted out of the committee by a vote of 15-6. Senators on the Republican side, Graham, Cornyn, Kennedy, and Tillis, joined all committee Democrats in voting for this nominee. He received a unanimous rating of well qualified from the American Bar Association, and he has the obvious support of the two Louisiana senators, Cassidy and Kennedy, both of whom returned positive blue slips, which is a committee process, and both of whom are Republican. Papillon had a BA from Louisiana State University and a JD from LSU's Paul Herbert Law Center before clerking for Associate Justice Catherine Kimball on the Louisiana Supreme Court. He entered private practice in New Orleans, where he specialized in the defense of products liability actions. And since moving to Baton Rouge in 1999, Papillon's main areas of practice have been personal injury and wrongful death litigation. Papillon has tried at least 33 cases to verdict, including more than a dozen jury trials. He's been a special prosecutor for the East Baton Rouge District Attorney's Office and a mediator for mediation cases in South Louisiana. He served as a special master in state court on 3 different occasions. He's deeply involved in the Louisiana legal community, having served as president of both the Louisiana State Bar Association and the Baton Rouge Bar Association. Let me repeat that. President of the Louisiana State Bar Association. The committee received several letters of support from individuals and organizations on his behalf. The former president of the Louisiana State Bar Association, the former president of the New Orleans Bar Association, 6 former opposing counsels, and treasurers of the New Orleans chapter of the Federal Bar Association. The reason I read that in detail is because if I went back home to Illinois, like I did last week, and told people we're considering judges before the Senate Judiciary Committee, which I chair, their first reaction is, can't you find a judge that both Democrats and Republicans agree on? Here's one. He wouldn't be here before us today, but for the fact that 2 Republican senators from Louisiana reached an agreement with the Biden White House for this man to have a lifetime appointment to the federal bench. Now, in case that sounds like front page news, it happens, and it happens more often than not. And the reason I come to the floor at this moment is to make sure it's a matter of record. During the Trump administration, Democrats approved what we call blue slips for 120 nominees for federal court. Some of those were 2 Democratic senators in a state like Illinois, but there was a level of negotiation and cooperation. I had, as senior senator from Illinois, I had to sit down with the legal counsel from President Trump's White House and put nominees on the table saying, here's one that we want and here's one that you want. I think we can agree on those 2. Let's move forward. And we did it. That happened, as I said, over 120 times with Democratic senators working with the Trump White House. We filled all of the vacancies in Illinois, virtually all of them, during the Trump administration with that bipartisan agreement. Today we have another one, 2 Republican senators with a Democratic president. It happens. And for it to happen, you need 2 things. The will for members to move and put nominees on the bench, and secondly, a person so qualified that both sides don't feel they'll be embarrassed by them. They're more judges and attorneys than they are politicians, And in this case, I think we found just that kind of nominee. Now we have a lot more to go. There are roughly 87 pending vacancies in the district courts across the nation. About almost half of them are in states with 2 Democratic senators, and the other half in states with at least 1 Republican, maybe 2 Republican senators. We're trying to reach a point where we have an agreement on this, and I think we can do it. This is an indication. I could list some other senators that I'm working with on the Republican side to fill those vacancies as well. I think that's what the American people are looking for. More evidence that we're trying to find some common ground despite the obvious political differences in this nation. This is an issue that I think is timely, and I wanted to bring the attention of the Senate to it on the floor this afternoon. Mr. President, when I went home to Illinois, I can't tell you how many people who know that I chair the Judiciary Committee ask me, what's going on with the United States Supreme Court? Obvious question, because in the last few weeks there have been disclosures about at least 1 justice on the court that have raised some serious questions. Justices have an important job to fill as one of the major branches of our government. They'll be issuing their remaining decisions for this term, and they'll recess soon until they reconvene in October. But the debate is still going to continue, even if they're not sitting in the court across the street. How will the justices spend their time during these several months when they're not in session? That's really the question. Rest up, possibly, or spend time with their family, possibly, or maybe take a trip or 2. There we have a question that is timely. We've learned through recent investigative reporting that some Supreme Court justices on the highest court in the land have enjoyed lavish travel during their summer months. That travel was often paid for by others, and the justices, in some cases, did not disclose this free travel as are required by law. These are the justices on the highest court in the land, and the question is whether they're following the law. They impose legal obligations on citizens across America. Are they living by the same legal obligations that affect them as justices? It's a pretty obvious question. Most notably, ProPublica recently found that in June 2019, after the court issued its final opinion of that term, Justice Clarence Thomas boarded a private jet and flew to Indonesia. Then the justice and his wife spent 9 days island hopping through the South Pacific on a yacht that was 162 foot long. ProPublica estimated the cost of chartering the plane and yacht at more than $500,000. But Justice Thomas didn't pay for that. The travel and trip were provided by a billionaire real estate developer, Harlan Crow, and several corporate entities in Crow's business empire. This is just one example of the largesse provided to Justice Thomas by Mr. Crow and his businesses. It's also been reported that Justice has regularly spent time at a luxury retreat in the Adirondacks owned by one of Mr. Crow's companies, again, free of charge. Mr. Crow has also bought real estate owned by Justice Thomas, including the home in which his mother lives, and Mr. Crow even paid for private school tuition for one of the justice's relatives. Justice Thomas did not disclose any of these gifts, or travel, or lodging, or other benefits. Now let me say at the outset, Justice Thomas is not the only Supreme Court justice, past or present, who's accepted gifts of free travel and failed to disclose them in a timely manner. But the scope and scale of the undisclosed Justice Thomas gifts has gone far beyond anything else we've ever seen. And this highlights the enormous gap in the ethical standards for the Supreme Court justices. We've known this for years. In February of 2012, 11 years ago, I first wrote to Chief Justice Roberts and urged him to adopt a code of ethical conduct to bind the justices, just like the code that binds every other federal judge in America. Chief Justice Roberts failed to act when I wrote him 11 years ago. Since then, the court's ethics problems have just gotten worse. Last month, after ProPublica published its first report on Justice Thomas' undisclosed travel, I renewed my call for Chief Justice Roberts to clean up the ethical mess across the street. And I personally invited him to testify at a hearing before our Senate Judiciary Committee so he could speak directly to the American people. You say, wait a minute, how many times does a Supreme Court justice come across the street and formally appear before Congress? Well, it turns out 92 different times since the year 1960. 92 different times. So they come across the street when they have something to tell us. I think they should be coming across the street to discuss the ethics of the court. This would have been an opportunity for the Chief Justice to reassure the American people and start to restore trust in the high court. I watch some of those news programs on Sunday morning. I'm a typical politician, and they have the polling data of what people think of the Supreme Court. The numbers are bad. They're almost as bad as Congress. And the fact is, they can do something about it, and they should. This court's trust in this court has fallen to the lowest level in 50 years. And unfortunately, the Supreme Court's Chief Justice didn't accept my invitation to walk across the street. Time and again, I've made clear one point I want to make clear today. The Chief Justice, John Roberts, has the ability right now, the authority right now, to impose higher ethical standards on his fellow justices, standards that would be transparent and enforceable. Wouldn't that be refreshing? He could take that action today, but for some reason, so far, he has declined the opportunity. And if he won't act, Congress must. We cannot tolerate a system in which the highest court in America has the lowest ethical standards in the federal government. And we certainly should not begin another Supreme Court summer recess where justices can take free trips and travel under an inadequate set of ethics rules. Last week, Chief Justice Roberts gave a speech, and he said something encouraging. I quote, he said, "I want to assure people that I'm committed to making certain that we as a court adhere to the highest standards of conduct." He said, "We are continuing to look at things we can do to give practical effect to that commitment." While I appreciate the Chief Justice's commitment, the fact is we need action, and he doesn't need to look far away for solutions. We have known for years what the court needs: binding rules and enforcement mechanisms, just like every other federal judge has operated under for a decade. If every other federal judge has ethical standards and disclosures, why does the Chief Justice for the highest court in the land not have at least those levels of ethical standards, but even higher? The Senate Judiciary Committee has the responsibility to exercise oversight over the federal judiciary. We take it seriously. We have held 2 ethics reform hearings so far this year, and soon we'll consider legislation to restore trust in the high court. When billionaires and other people with interest before the court try to make friends with the justices through gifts and luxury giveaways, and when they obtain special private access to these justices for themselves and their other friends, it's a serious problem. At minimum, it creates an appearance of undue influence that erodes the public's trust in court impartiality. And we don't yet know the full extent of the benefits that Harlan Crow and his company gave to Justice Thomas and his family. Nor do we know yet how many other people and companies with interest before the courts may have gotten special private access to Justice Thomas or some other justice through trips and lodging that people like Harlan Crow have sponsored. My Democratic colleagues on the Senate Judiciary Committee and I sent a letter to Mr. Crow and the 3 companies that we think sponsored the trips for Justice Thomas. We asked him, tell us about the gifts. Tell us about the access of people to Justice Thomas during this hospitality extravaganza. The information would be valuable for us in writing a law for the ethics standards of the court. Mr. Crow responded through his attorney last week with a letter that took some astonishing legal positions. He basically claimed that Congress lacks the authority to either legislate or conduct oversight when it comes to the Supreme Court's ethics. He also tried to assert separation of powers as an excuse not to answer our questions. Of course, Congress has enacted many ethics laws that apply to the justices, including a law we passed just last year, bipartisan law sponsored by a Democratic and Republican senator on stock transaction reporting. The justices have announced they're going to follow those laws. And Mr. Crow is a private citizen, not a branch of government. He can't claim separation of powers as a reason not to provide information pursuant to a congressional oversight request. He's a businessman. He's not a branch of government. If Mr. Crow is convinced he's done nothing wrong, what does he have to hide? Senator Whitehouse, the chair of the Federal Courts Subcommittee, and I responded to Mr. Crow last week, informed them that he still has until next Monday, June 5th, to provide the information we requested. As I mentioned, we'll soon be considering legislation in the committee, and his information could be helpful in our legislative effort. Let me close by reiterating that Chief Justice Roberts does not have to wait on Harlan Crow or Congress. He can clean up this mess today by adopting a resolution binding the justices to higher ethical standards. This is the Roberts Court. History is going to write the history of the Supreme Court in the name of this Chief Justice. It happens all the time. He is going to be known as the Chief Justice who ignored an ethical challenge that went to the heart of the integrity of the court, or as a Chief Justice who finally responded in a historic manner to do the right thing for disclosing to the American people exactly what the conduct is of his justices. Chief Justice Roberts has known for more than 10 years that this is a problem and the solution is within his authority. He should act before the end of this Supreme Court term. Don't leave this hanging. Don't leave town, leave Washington, all the justices of the court, unresolved. I honestly believe, whether I voted for them or not, that there are justices in that court who are uneasy and uncomfortable with the current state of affairs. They are trying their level best to follow the law, and they can't explain why others are not. They want to have an opportunity to prove their own reputations and their own integrity, and they should. The Chief Justice should be listening to them, and I hope he is. It's the Chief Justice and the court's time to act. If they don't, we will. Mr. President, I yield the floor.